More likely than not, that 0.01% is all it takes to tip the scales of justice. Join us as Inner Circle legend Charla Aldous, Eleanor Aldous, and Caleb Miller walk you through the critical moments, big decisions, and bold strategies that win high-stakes cases and show you how to turn that 0.01% into a game-changing verdict. You're listening to the podcast where winning is more likely than not. Produced and powered by LawPods.
Hello, welcome to our first podcast, More Likely Than Not. Well, this is the first time we're doing it again.
True.
The first time we did it and we screwed up on the sound or something. And anyway, this is a podcast from Aldous Law, and I've got a confession to make. I'm doing this because the youngsters in the firm, that would be Caleb and Eleanor, told me we need to do a podcast. But the more I learned about it, I thought this will be fun. Maybe anything that we've learned over the years that we could help other lawyers learn to better represent their clients, then I'm all game in. We got the name More Likely Than Not for obvious reasons. It's the burden of proof in civil cases. And I'm here with Caleb Miller. Caleb's been practicing, I think, about 10 years now, haven't you, Caleb?
10 years, yep.
Oh, don't say it like that. Remember your audience.
I'm a youngster.
There you go. And he's been here with me for 7 years. And then Eleanor Aldous, and yes, we are related. I gave birth to her. She is my daughter.
I was going to say you're my sister. Everyone knows it.
Oh, please. And she's been practicing 6 years, but for 3 years here at Aldous Law. So we were trying to think about what we were going to talk about. And the first thing that came to mind is right before COVID, we were complaining about it until we got isolated forever, and then we were grateful for it. Our small firm tried 4 cases in a year to a verdict, and we got 8-figure verdicts, I think, in all 4 of those cases, didn't we, Caleb?
That's right.
And we're going to have Eleanor to kind of walk through those cases. She was not with the firm when we tried them. So she's going to walk through and ask Caleb and I some questions about those various cases, because we think there's some things that maybe lawyers could learn from what we did in those cases that seemed to work. And if there's anything that we can give the other people in our legal community, plaintiffs, lawyers especially, help in representing victims of wrongdoing, then we are game and excited to do it.
But before we can start, Charla always does this. She tries to go right past an introduction of her. We're going to assume that some of the people listening don't know who Charla Aldous is, and I'm going to interject and tell you a little bit about her, even though she doesn't want me to.
I'm used to the butts.
Well, and before you do, everyone needs to know her name's Charla Aldous, and she's from Sherman, Texas.
This is true.
Yes, that's the foundation of everything you're about to hear.
That's right. So Charla's been practicing for about 40 years. She's tried well over 200 jury trials. I mean, she's won basically every award you can. She has verdicts all.
I thought you were going to say I've won every case, and I'm like, no. If you show me a lawyer that hasn't lost a case, I'll show you a lawyer that hadn't tried many. Okay,
No.
I'm glad we cleared that up.
No, I haven't said you won over 200 jury trials. I assume most of those are wins, but some of them probably aren't.
Absolutely.
I have losses myself as well. Charla's tried a ton of jury trials all across the nation. She has a lot of 8- and 9-figure verdicts. I'm only going to talk about some of her awards and accolades because there are a lot. She was inducted into the Inner Circle of Advocates, which is one of the most prestigious organizations for plaintiff lawyers, in 2007, and was one of the first females ever inducted, which is just amazing.
We love our lady lawyers.
Yes, we do.
That's right. She serves on the executive committee of the International Trial Lawyers Association. She has
International Academy of Trial Lawyers. That's okay.
Sorry.
I just got to get the name right.
There are too many organizations.
I know, right? They
to
all
keep
blur together after a while.
She has the Lifetime Achievement Award from Texas Trial Lawyers Association, which is the best award you can get in our plaintiff organization here in Texas. She was the number 2 trial lawyer in all of Texas for super lawyers this year, and the number 1 trial lawyer for personal injury and med mal from National Trial Lawyers Organization. And like I said, I have to stop here or I'm going to take 30 minutes and butcher a lot more names of organizations.
Wait, Caleb, you missed the most important award. She is the mother to Loretta May and Lucy Liu, her 2 Chihuahua rescues that come to the office every day with her. I think they need an honorable mention.
Yeah, we call them our 4-legged restraining orders.
Yeah, they're like 8 pounds each. So, well, Lucy's 10 pounds on a good day.
True.
I forgot to write that one down.
Yeah.
But now that we have that one out of the way,
Yeah.
why don't you go ahead and start us off, Eleanor?
Yeah, and I'm super excited to talk about these amazing results that you guys got. And of course, I wasn't here, so whatever, it's fine. But before we do that, I do think it would be helpful if our audience, in addition to hearing all about how amazing Charla is, which of course she is, but also learning a little bit about the kinds of cases our firm handles so that the audience understands what we've worked on, what we continue to work on. So Charla, can you just give everyone a little sense of the types of cases that we handle and take it away?
Sure. Since I started the firm, I don't know, 30 years ago. I can't remember the exact time frame anymore. But we've done a wide variety of cases. I mean, I've tried everything from offshore tax shelter cases to defamation cases, medical malpractice, sexual assault, everything. But what our firm really specializes in is catastrophic injury and wrongful death. But we do a variety. We do some sexual assault cases. My view on looking at cases is there a wrong that's been done that needs to be accounted for? And are there damages there? And if they are, then we're in.
Thank you. That's true. We love our clients. We love representing them. We love getting a just result if we can. So let's just dive in. So 4 trials, 1 year, 4 8-figure verdicts. It's a lot of numbers, but that's very impressive and exciting.
It's a lot of brain cells.
I know.
Too.
I think in total, and Caleb calculated this, I did not because, math, but it was about 114.6 million in verdicts in 1 year, which is, amazing results for your clients. The first one that you guys tried was the Brown case, and that was a dram shop case, and the verdict resulted in $25 million. So Charla, can you just kind of give us an idea of the facts of that case?
Sure. It was an extraordinarily sad case. Jerry Brown, we represented his mother, and he was her son, obviously. And his best friend was Josh Brent, and they were both Dallas Cowboy players, so there was a lot of news publicity. Anyway, they had been at a local bar here in Dallas, and Josh got behind the wheel of his car. Jerry was a passenger, and he left the bar, and shortly thereafter they were in a one-car accident, and it killed Jerry. Josh went to jail for vehicular manslaughter, and Jerry's mother contacted us and said she just wanted some answers as to how this could have happened so shortly after they left the bar. So we did an investigation on it, thought it was a meritorious case, and decided to take it on.
And when you say a meritorious case, hearing those facts, all of us immediately go to, well, was he overserved when he shouldn't have been, right? So I assume you guys did an investigation and realized that was the case. Is that true?
Yes, we did an investigation. And I'll tell you this, there were some good things and bad things as far as the value of the case, the merits of the case, and our investigation. Because there was some video at the bar. It was the Beamer's bar, and it was a table service bar. And there were some videos of Josh throughout the evening, and he looked perfectly sober. He was a big guy. He was like refrigerator size big and huge.
Yeah, he's a Cowboy.
He's a Dallas Cowboy. And I don't know football, but he played one of those where you have to tackle people a lot.
He was an offensive lineman.
There you go.
Yeah.
I love how Caleb says that to me as if I know.
I mean, it'll orient the audience to how big he was, because those guys are huge in the NFL.
Yeah,
he's a big guy.
Anyway, we saw the video, and he did not look intoxicated at all. But
at the bar.
At the bar.
Okay.
And then we had video of them leaving the bar, and there was a construction area outside the bar, and Josh was able to navigate that construction area perfectly. I did not look intoxicated. But I think it was 6 minutes after they left the bar, the crash occurred. And so intuitively, I thought, if he was drunk 6 minutes after he left the bar, surely he was obviously intoxicated. He just hadn't handled his alcohol, fairly well. But what we did in that case, I contacted my good friend Mark Mandel, a great plaintiff's lawyer in Providence, Rhode Island, who wrote the book on case framing. And I always value his counsel when I'm working on a case. He said, Charla, it's all in the way you frame this case, which was brilliant. And normally in a case like this in the past, I would have started and gone chronologically through what happened, where Josh and Jerry had been the night before, who they'd seen, where did they go.
And chronologically, you mean also in terms of witnesses, right? You would have called the witnesses that fit the timeline of chronological order.
Exactly. But what we did in this case, because of the magnificent suggestion of Mark, is we had met with a police officer who investigated the accident and asked him what was his view of Josh Brent at the site of the accident. And he said, he was drunk, no question. And we said, was he so obviously intoxicated that if he had tried to leave the scene of the accident, you would have arrested him? He said, absolutely. So bingo, that's where we framed our case. We called the police officer as our first witness. So the jury, in their mind's eye, is seeing a police officer, a man who's trained to know these things, just as a bartender should be trained to know these things, said that 6 minutes after Josh left that bar, he was so obviously intoxicated, he would have arrested him if he hadn't stayed at the scene. So I think the jury from that point thought, okay, then try to tell me why he wasn't drunk, because they're assuming that he was. And it was a brilliant way, and it made me rethink how I try all the cases on who I'm calling as the first witness. Another thing that we really had to walk a tightrope with was Josh Brent was Jerry's best friend. And Jerry's mother, Stacy, loved Josh like a son, but she wanted accountability for this bar. And Josh was devastated and heartbroken that he'd killed his best friend. Went to prison for it, and we made the decision to call him live. And it was very painful. I mean, he sobbed on the stand. He was remorseful. He said, yes, he did have too much to drink at the bar. He was intoxicated. He wished he had not got behind that wheel. Then we were able to weave into our arguments that the criminal justice system deals with people like Josh. And he had received his punishment.
Yeah, because a lot of jurors we've known, whenever there's a wrongdoer beyond the bar or corporation, a lot of times jurors want to place all responsibility on the person who got behind the wheel, for example. So you guys really had to contend with that and trying to find a way to turn him, quite frankly, into a victim.
He really was. I mean, what we tried to show is he's going to have to live with his death for the rest of his life. He served time. He lost his career. But if the bartenders and the bar had done their job, Josh would never have been in that situation.
What I'm hearing, what I'm learning is the first part is we control the narrative, right? We frame the story, we frame when it starts. And the way you guys did that in the Brown case was starting with the police officer and starting with the assumption, of course, he was drunk and working backwards. And then the second portion of that is when you have a troubling person involved in the case who the jury's going to want to naturally blame, you got to figure out how to deal with that in a way that's effective, but keeps the focus on the actual target defendant.
You got to hit it head on. You got to deal with it, right from the get-go. One other thing that surprised me in that case was, I can't remember the amount of damages, but it was several millions of dollars for Jerry's conscious pain and suffering, which was a little bit surprising to me because I didn't know if a jury would award money like that to somebody who'd been drinking at a bar and got into a car drunk with his drunk friend.
I think it was $10 million.
Yeah, it was a lot.
It was a lot.
Yeah.
One other thing I want to interject from this case that Charla touched upon a second ago is I think this is the first case that made us rethink witness order and make us sit down on every single case before we go to trial and talk about who makes the most sense for this case to start us out.
Yeah, it's funny. I remember we tried a case, our law firm, in conjunction with another law firm here in Texas, to verdict and got a $71.95 million verdict. And it was a complicated case, but I remember one of our very first conversations was, who do we call first? And I think collectively, but Charla really leading the charge, we decided to call the corporate representative for the defendant first. And that proved to be a very powerful move on our part. So I think you're right, Caleb. Every time you got to really think about who's going to be the most impactful, because a lot of really great trial lawyers tell us it's the first and the last.
Yeah, I historically have always called an adverse witness first in my cases. I just think it's really powerful to do that. And so calling the corporate rep was more the norm for me, but then calling the police officer was out of my comfort zone. But I was glad to see that I could change courses, and it worked.
And just one more example, I remember we tried a products case a couple of years ago in conjunction with another law firm here in Dallas, and you called the defendant's expert first.
Did I really?
Yeah, you did.
Did it go well?
Oh, yeah. Because
I can't remember.
I don't
so
remember
it was
that
two
either.
defendants pointing the finger at each
Oh,
other.
I sure did.
And you called one of their experts and turned them on the other defendant, the one that we were really targeting. And so, again, you really think outside the box. And quite frankly, you got to be fearless to do that.
I had forgotten that we did that.
That could go a lot of different ways.
It really could have. I must have been really feeling it at the time, because when you said it right then, I'm like, no, I didn't do that. Surely
you
I
did that. Yeah. Yeah. And the funniest part is in the middle of it, she turns to me and goes, "What's the name of the product again?" Okay, so that's the first case, the Brown case, the Dram shop, $25 million. And then we move on to Milburn, and that was a product defect case, and the verdict result was $37.6 million. And I think, Caleb, you are best suited to kind of give us the underlying facts so we can orient the audience.
Sure. So this case happened, I guess it would have been 2016, 2017-ish. Our client, wonderful person. Her name is Sarah Milburn. She's testified before our legislature against various bills that affect her, but she's doing so much right now. But let's go back a few years. Sarah's out with some friends in Dallas. They're doing the responsible thing. They'd been out drinking a little bit. They decided to call a rideshare. None of them are suited to drive. And so they get in this rideshare, and it's a Honda Odyssey van. And these Honda Odyssey vans had third rows, and the third rows had this seatbelt design that went from the very top of the ceiling, connected down to a buckle, and then you would have to take another belt and cross that over.
So let me make sure. So you reach up with, for example, your right hand and you pull it straight down and you buckle it. And then you have to do an additional buckle across the lap.
So essentially there's two belts. There's a shoulder belt and a lap belt.
Okay.
And obviously this is not how we're used to wearing seatbelts.
I know, honestly, even describing it, I was like, how does that work?
So the normal person gets in a vehicle, they pull from up top diagonally across their body.
Right.
And in one buckle, they're done.
Yeah.
And so what happened was Sarah got in this van. She put the seatbelt on like she did every other time. Shortly after they started driving, the van was in a crash with another vehicle, and it flipped over. Most of Sarah's friends were not wearing belts, and they all walked away from this crash.
None of them were, other than her.
Oh, was it none?
None.
Yeah, so nobody else in the van, other than Sarah and the driver, were wearing seatbelts. And Sarah was the only person injured. And because of the design of the seatbelt, when she put it on, she thought she did everything right. But what she didn't do was she didn't buckle it into the first little buckle that then connects to the lap belt. So she had this shoulder belt from the ceiling going very high across her neck down to the belt like we would normally do it. So when the van rolled over, it caused a submarine injury, which basically means the belt caught her at the neck and it ended up breaking her spine. The result was she became a quadriplegic from this event.
I mean, and wasn't Sarah early 20s, just starting out her life?
She just graduated from college.
Yeah. You know, an interesting fact is I actually grew up with Sarah. She went to school with me. And when I learned about this case, I just, broke my heart for her. So it's crazy how the world will come back at you 3 times.
Yeah, it was absolutely devastating. And originally, you look at a case like this, you say, okay, there's not enough money in the world to take care of this injury. And you worry, where's the insurance? And so we do what we do in every case with these sort of damages, or in every case just altogether, and you look at every angle imaginable. And so after looking at the basics, okay, the driver, maybe the rideshare company, some of this stuff, we said, that seatbelt just doesn't seem like it was designed very safely. And so contacted some experts, and they said, yeah, it's counterintuitive. You wouldn't ever put on a seatbelt the way it's designed to put on because it goes against muscle memory.
So it sounds like this was a defective design.
And that's exactly what we made it.
Okay.
So after a couple years of having this case, it became a defective design case against Honda.
Okay. And as we all know, product cases are very confusing to jurors. You have to really break down those complex issues into a more narrowed, very clear, very simple, very digestible kind of story. So how did you guys go about doing that? Were there some tools you used, and what all did that entail?
I think the first thing we do on any case we get involved in that's with another law firm, or if we parachute in for trial, first thing we all do, and you know this because we do this on our cases now, is you look at it and you say, what is the message I have to get across to the jury? How can we make this case as simple as possible? The problem we see on a lot of cases is people have a big case, they think they need to depose 30 people, they need to have 12 experts, and they need to try this case in 5 weeks. And I would say in the vast majority of cases, that's wrong. You need to present a story that is simple effective and that will stay with the jury when they're deliberating. And so we looked at this case and we said, how can we explain how complicated the seatbelt was and why it would go against our muscle memory? And what we decided to do was we created a demonstrative test involving normal people. So imagine, you have a focus group, you have people from Craigslist coming in, you tell them about your case. Well, what we decided to do was set up the van in exactly the same way as it was the night that Sarah became injured. And we set 2 people in the van in the back, just like it was that night. And all we did was tell the people, sit down, put your seatbelt on. And that was it. And then we recorded.
You just videoed it.
And we videotaped it, and we gave them no other direction. We didn't want to influence them at all. And so we had this demonstrative that showed, and Charla knows this better than I do, the number of people that used it incorrectly. But I want to say it was out of 60 or so people, there was only 3 people that used the seatbelt correctly.
And I guarantee you those 3 people were people who had had experience with that specific belt before.
It was astounding to watch. It was troubling to watch, actually, as the study was going. The people would say, okay, you want me to put my seatbelt on? And they would look for it. They'd find it in the ceiling, and they did exactly what Sarah did. They brought it over and thought they were safe. And out of 60, 58 of them put the seatbelt on exactly as Sarah did. And we did this in conjunction with our expert, human factors expert, who is fabulous because this was a human factors case. It's not that the seatbelt itself was designed defectively. It was designed in a way the average user would not understand how to use it appropriately. And that's how we developed the case from a human factor standpoint. So Jo Ellen Gill, who is a fabulous human factors expert, told us, she said, muscle memory, people are going to reach up, pull it across, reach up, pull it across. That's human. That's what we as humans learn to do. And that study clearly showed it. And it was astounding. When we finished that study, we're like, holy cow, we really are right on this.
So you guys basically showed the jury exactly what we all know intuitively, which is this is a very confusing design. And unless you're probably had prior experience or are, quite frankly, of a certain generation, you're not going to know how to use it.
And the thing about this product, it's the third row and it's only the middle seat. So what are the likelihood of you're going to have somebody in that middle seat, number one, and number two, have a wreck? It just was the perfect storm for Sarah.
Oh, that's so sad. I think the lesson pulled from that is try to show the jury exactly what it is you're talking about in a very simple, clear way.
Keep it stupid, simple. Simple, stupid. Which one is it?
Keep it stupid, simple.
There you go.
Well, that
keep
works
it
too.
simple, stupid. But I also like keep it stupid, simple.
There you go. Either way, kiss.
I think our job, lawyers that talk to normal people, which is what we do, we're lawyers that get to explain things to anybody, right? And so if you're trying to explain things to somebody who doesn't know the law, who doesn't know what a product defect is, who doesn't understand automotive issues, which frankly, we didn't have a lot of experience with ourselves, you have to sit down and you have to think about, how would I explain this to my dad? How would I explain this to my 12-year-old son? How would I explain this to somebody I know outside of the law? And it doesn't matter what kind of case you have. Those are the questions you have to ask yourself. And you have to say, what is the easiest and the shortest way I can get this message across to the jury? And if you can do that effectively, I have a hard time seeing how you're going to lose a case.
You know, in the Brown case, the Dram shop case we just talked about, obviously Jerry had passed away. But in this case, Sarah was still alive. I mean, obviously she had devastating injuries. She was relegated to a wheelchair. How did you guys manage her presence in the trial?
I did what I always do. I'd never let clients be in the courtroom during voir dire. But even during voir dire, I did not, my portion of the voir dire, I did not tell the jury how seriously injured Sarah was, because I think it's really important to not let them know the severity of the injury, because you're not going to be able to weed out the jurors who are going to keep the damages down. Mm-hmm. So when I talked about millions in mental anguish, millions in disfigurement, and all hundreds of millions, they didn't know how injured Sarah was. So that's the first thing. Second thing, I do this with most clients who are severely injured. We did not have her sit through the trial because it desensitizes the jury to her condition. Sarah is a very ebullient outgoing person, and we wanted her to be a breath of fresh air in the trial when she came in. Her parents sat through the entire trial, but she was only there for her testimony and during closing. And I thought it was very powerful because when she willed herself into that courtroom, you could have heard a pin drop, and every eye was on her the entire time.
That makes sense to me. So the takeaway is don't desensitize the jury to the awful thing that's happened.
Exactly.
Well, and what Charla also said about voir dire, the reason Charla does not have our clients in for voir dire is because, like she said, if you're asking people, can you be fair in this case? Can you consider awarding the amount of money we're going to ask you to award? If they know somebody's a quadriplegic, they're likely to say yes. But that's not helpful.
Right.
You want to see what somebody's preconceived notions are before they know what the injuries are.
Yeah, not to mention, I think a lot of potential jurors would feel uncomfortable admitting to bias or prejudice when someone's looking them in the eye.
And I think that's true in every case. I think you should, my own personal opinion, is not have your clients there in voir dire because it allows the panel to be much more open about their thoughts and feelings and prejudices.
And I think Charla says that during voir dire. You say you ask your client not to be here because you want the panelists to be as open and honest as possible and not to feel like they have to hold back.
Yeah, I think Charla has done that in almost every case that I've at least been a part of. You have explained to the jury, do not blame my client for her not being here. That was my choice. If you're going to blame anyone, blame me. And then I think the final portion that we wanted to talk about with Milburn is you guys have had to eventually come to some type of number, right, that you're going to ask the jury. We always struggle with that, right? What's fair, but also what's going to get us to that fair number. So we have often done something called a big data study, and I think you guys did that in Milburn. So Caleb, can you tell us a little bit about that?
Yeah, so this has become a routine practice of ours now, but I want to say Milburn may have been the first case we ever used a big data study. Well, big data studies are, it's like another focus group. You prepare scripts that are not supposed to be super argumentative or one-sided. You want to make them as neutral as possible. And then you give those scripts to 300, 400 people, and then you ask a series of questions about those scripts. And so the idea is, what do normal people think about our case? What issues do they identify as more important than others? Would they put some contributory responsibility on our clients? Are they going to put a lot on the driver? Are they going to put any on the rideshare company? You ask all those questions ahead of time so that when you go and try the case, you know how you can try your best case possible. But not just that, you know what the damages are likely going to be and what you should ask for. And so we use John Campbell, and we've used John and Alicia Campbell for a number of years. The big data studies, in my opinion, are probably the best resource available for plaintiff lawyers prior to trial. If somebody came to you and said, hey, I can tell you what the result of your case is going to be before you try it, why wouldn't you do that?
Yeah, but look, y'all, we understand there are some folks out there that have cases that, cost-wise just don't merit it, because I'll be completely honest, those big data studies, they are expensive. So, you really got to be at least discerning in that way. Do the injuries merit that kind of cost? And that's something you'll have to make the determination on a case-by-case basis. But I completely agree, Caleb. If it's the right case, it's invaluable. It is so helpful.
And let me tell you one thing that big data studies have helped me, and it solidified what I thought but was a little anxious about, is they will do different asks. Like I think in Milburn, I don't know the exact numbers, but one they asked for $100 million, then $150 million, and then $200 million. And then they weighed, did the higher ask increase the amount of the verdict? And inevitably, every time it does. But my next question was always, does that higher ask offend people? And I have just been shocked by the fact that it does not. And so it's allowed me to be even bolder in our ask. And one thing that I have done, I think most all the time, if I recall, is when I'm awarding, obviously a life care plan is what it is. Those that have price tags, you can tell the jury what the numbers are. But I usually give ranges in closing on what they should award, because I want to empower the jury and let them understand I'm not telling you this is what you have to do, but I'm giving you a reasonable range of what I thought would be fair. And I think think that's a really good thing to do.
I think the cool thing about them too is they'll tell you, all right, if you ask for this amount, you're going to get this amount, right? It's not the same amount, but it tells you, listen, if you ask for 200, I can guarantee you're going to get 80. It's just a very helpful way in building confidence.
And these studies are very scientific. I don't understand all the science behind it, but I can tell you when we've used them and the results from trials have come out on the contrib, they are spot on the joint and several, they are spot on, and on the damages, they're always within a few million of predicting what the jury's going to do.
Yeah, I think what we can do is in our show notes, we'll include that video that we did in the Milburn case, if we can, of the seatbelt issue. And then we can link out John Campbell and Alicia Campbell as well for folks who, have a case that suits those needs. So we had Brown, we had Milburn, and then next y'all tried the Fletcher case, which was a sexual assault case that resulted in a $32 million verdict in a pretty conservative venue.
That's darn conservative you can get.
Yeah, what venue was it?
Denton
County, y'all. For those who are not in Texas, that is a very conservative venue. All right, so Charla, can you just tell us what happened to this sweet girl?
Yes, and I can say her name because she gave an interview to the Dallas Morning News and disclosed her identity, and I was proud that she felt strong enough by the time all of this was over to do so. We took this case not because there was any money in it, because there certainly was not, but Isabella Fletcher was a freshman at a local high school, and she had gone to a party. A football player had drugged her, basically, and raped her. And it was just horrific. It had devastating consequences on Ellie's school. She dropped out of the school she was in. She was a cheerleader. She was an honorable, straight A student, everything you would want your child to be until this happened, and it just devastated her life. Because of what I believe perceived to be some political things, the young man's family was very wealthy and had a lot of political clout in Denton County. He was not criminally indicted. I'm not going to go into all of the facts of that, but it was very hard on Ellie when that happened. So the family came to see me, and I literally did some soul searching, and I thought, this child needs someone to believe in her, and I've got to take this case. So we filed it. It was a rape case, and it pretty much was a pro bono rape case. And Ellie, through all horrible things she had been through, had developed a real hard shell, and I called her my little porcupine, because once you got through the quills, there was a lot of softness there. And she gave me a crystal porcupine when the case was over to remember her by. But the bottom line is we tried the case. We took very few depositions, but we went and tried it in Denton County. And the young man, since he had not been indicted, did not plead the fifth. He was not one bit remorseful. What I thought was disgusting is his mother brought her prayer group every day to the courtroom to stare at Ellie as we proceeded with the trial. And I'd never seen, in the couple of years I've been representing her, never seen Isabella cry. And the jury came back, and they found for her, and they awarded, Caleb, what was it?
$32 million.
Yeah, $32 million, which was unheard of in Denton County. And I heard a sob, and it was Ellie. And she said, they believed me. And after the verdict, the jury retired to the jury room, and they told the judge, they said, we'd like to see Charla and Ellie in our jury room. We went back there, we walked in, and they did a standing ovation. And it was one of the coolest things I've seen in my career. That little girl melted, and she said, y'all believed me. And they said, not only did we believe you, we are so much in awe of your strength and courage to come forward like this. I have no doubt that that verdict changed her life, because she was validated. There was somebody that would fight for her. 12 strangers believed in her, and we'll probably never collect a dime of the money, although that little punk, if he buys a house, we've got a writ of garnishment on him. We'll come from him at some point maybe. But anyway, it's one of those cases that's feel good. It was not financially rewarding for our firm, but man, did it feed our soul.
Gave her validation. It's interesting because a lot of the sexual assault cases we handle are usually directed towards corporation or corporate wrongdoing that facilitated and or allowed for the sexual assault to happen. And a lot of times, unfortunately, if there's not a criminal prosecution, we know that jurors are going to make a lot of judgments about that. And so sometimes we steer clear of it, which is such a shame, because we know, just being educated people about these topics, that for a lot of reasons, criminal prosecution doesn't happen. A lot of, in my opinion, unfair reasons. But in Ellie's case, it's amazing because in a way, the criminal system failed her.
Right.
These kids failed her, obviously, in what they did, and her school failed her. She had been failed by everyone, right? And as we know, secondary victimization can be just as painful as the original assault. And so her getting that validation through that verdict and those 12 jurors telling her, we believe you, I'm sure transformed her life.
It did. It was, it's something that I don't regret doing. And we did investigate it. I mean, I went and met with the detectives. I met with the DA, so I could fully understand why this young man was not indicted. And I never doubted Ellie for a minute. What she was speaking the truth. It was so disgusting. I'm sorry, Caleb, but the day after the rape, he went to school with his blood-splattered shorts and told people that was Ellie Fletcher's virgin blood. I mean,
what a peach.
And so when I heard that, I'm like, okay, I got to do this. This is disgusting. Because that young man, I mean, if he's going to do it once, it'll happen again.
Absolutely.
And at the trial, like Charla said, he just had no remorse. I mean, it's unbelievable to see somebody up there with what I would perceive as no moral standing at all.
Was there video or something like that of the?
No.
Okay, I'm not sure why I thought that. So
what I was going to say, just to give you frame of reference here, is we tried the Jerry Brown case in December of 2018, I think. The Milburn product case was like 3.5 weeks. And that went at the end of, I think it was like the end of January to mid-February. I was doing the pretrial in the Fletcher case when Charla was trying the Milburn case. 3 days after getting a verdict in Milburn, we started the Fletcher trial. So that was one part that you probably don't want to remember. But Charla finished this trial. We're in the office. It's like a Thursday or Friday, and we're starting our jury trial in Fletcher in Denton County on a Monday. And I just remember Charla just looking, and she was like, all right, let's go.
I had forgotten that. We literally, Caleb came over to the Milburn trial and said, guess what? And that's what, so we're going to trial in Fletcher. I said, when? He said, Monday. I'm like, oh my goodness gracious, I hope we're done with Milburn. We got done in the nick of time and literally had the weekend to get ready for Fletcher. We slept a lot when that one was over.
I bet. So it sounds like, sometimes justice requires us to take a case. It just does. And then, don't be afraid of those conservative jurors with the right case.
Exactly.
And one thing you need to know about our office is we do things like this quite often.
Yeah.
And we've always had cause cases. There are always cases that'll be in our office. We have really, really good cases, and those allow us to do the pro bono ones or to do the ones that just hit us hard somewhere where we feel like we have to.
Yeah.
And so the Fletcher case, that's not like a one-off case for us. Every year we have what I would consider a cause case.
Yeah.
That will require us to do something more than getting compensation for the client.
At least one.
I believe it's our duty as lawyers to do pro bono work. And I usually try to do it when there's societal issues, that are involved as well. And sexual assault is a big one. I tell people, we probably make more money than we should on some cases, so we give back on others. It as I said, it feeds our soul.
Absolutely. All right, so that's Fletcher. So we had Brown, the Dram shop. We had Milburn, the product defect. We had Fletcher, the sexual assault. And we're going to round this puppy out with the Greyhound case, which was a wrongful death case that resulted in a $20 million verdict. So, Caleb, can you tell us a little bit about this case?
Sure. So our clients were just absolutely wonderful people. One of them was an author. The other one was a doctor. And they had 3 children. And their oldest son, named Hunter, he had some issues growing up where he fell in with the wrong crowd, got introduced to cigarettes, and then that became marijuana, which eventually turned into a heroin addiction. And what we learned from his mother, Paula, is that Hunter was not an addict. He was somebody who struggled with addiction. That addiction did not define who he was as a person. But what happened was Hunter, he had tried rehab facilities in the past, and it was always something that his family wanted to help him with. And he had made a decision that he wanted to turn his life around. And he had some family members in Northern California, and he had some other resources he had found in Northern California. And he had made a decision to go from Seattle area to Northern California to try to turn his life around. And so what his parents did is they practiced tough love. They always tried to help him, but they wouldn't give him cash. They wouldn't give him those sorts of things because they would know he would use it for drugs. So what they did is they bought him a one-way Greyhound ticket from Washington to Northern California, packed his favorite snacks, sandwiches, gave him his favorite books in a bag, and a burner phone.
And just for people who don't know, Greyhound is one of these bus companies that transports people all across the country.
Yeah, and it's common for people who have struggled with addiction or who may have other struggles and not have ID to take a Greyhound bus because it is one of the only forms of transportation that doesn't require ID. And so Hunter would always go get a driver's license or other ID and he'd lose it. Or sometimes a lot of people when they're living on the streets or, in these shelters, they get their items stolen. And so he had some issues with ID and keeping phones and that sort of thing. And so he decided he was going to take a Greyhound bus and he was going to meet with his, I think it was an uncle in Northern California who was going to help him get into this facility. So what ended up happening was on this Greyhound bus ride, the bus is required to take a 30-minute meal stop. And they stop at these truck stops basically in the middle of nowhere. So the Greyhound bus driver stopped at a 30-minute meal stop in the middle of nowhere, Oregon. It's, I don't know if it's like 11 or 12 a.m. It's sometime late at night. And they go to this bus stop. They're told they have 30 minutes to go and get food, use the restroom, whatever they need to do. And then they have to be back on the bus. Well, what ended up happening was Hunter was the last person off the bus because of where he was sitting. So he was the last person in line to get food. About 24, 25 minutes after they were told they have 30 minutes, this bus driver honks the horn, says, "I'm leaving." Everybody runs back on the bus. Hunter's still waiting for his food. The bus driver doesn't do any kind of passenger count. He doesn't wait. You're supposed to do a count. You're supposed to go and look for people if you can't find them on the bus. He didn't do anything.
When you say supposed to, is that based on Greyhound's policies?
I would say it's industry standard based on common carrier.
Okay.
But it was also specifically in their policies. So both.
Okay.
It was something that's widely accepted within the industry, and Greyhound, has it written about 100 times in their policies.
Of course they do.
Yeah, and they don't practice the things they say they're supposed to do. So what happened was the bus starts to leave. All of Hunter's stuff is on the bus. Everything he owns. People stand up and say, "Hey, there's a boy still waiting." The bus driver says, "I don't care. I'm leaving." So Hunter starts to walk after the bus. It's going very slow, starts hitting on the side. Everybody stands up. "Stop, stop. There's somebody outside. There's somebody outside." The driver says, "I don't care." He keeps driving. Then what ends up happening is the wheel of the bus catches Hunter's foot and sucks him under and ends up running him over and killing him. And so his parents came to us, wanted us to look at the case. We had a great co-counsel out of Oregon because Greyhound was headquartered in Dallas and they wanted to file in Dallas. So we performed this investigation. We looked into what the causes were and ended up trying the case.
Yeah, Jane Paulson and Coletti was the lawyer that brought us in to the case. We talk about bad facts. There were some bad facts in this case, and we learned about those right from the get-go. And Hunter, when he died, had a syringe in his pocket and had heroin in his system. So he had been doing drugs either on the bus or shortly before he got on it. I think some law firms would say, "Hey, we cannot represent somebody that, number one, had an addiction to heroin." And I got to tell you this, his mother, Paula Becker, I called him an addict one time. She said, "Please don't say that about my son." She said he was a young man who was addicted to drugs, but an addict does not define him. That really stuck with me.
Well, that's kind of similar to when, and we can edit this out if people don't want to hear it, but it's when someone calls someone an illegal.
Yeah.
No, this is a person who's in the United States without legal documentation.
Exactly.
You know what I mean? Or whatever the proper term is.
Exactly. So anyway, he did have heroin in his system and he had a syringe in his pocket. And we had to deal with that head on with the jury.
'Cause I think the jury would be quick to assign all blame to Hunter in that situation, thinking maybe he wasn't in his right mind and he put his own foot under the bus wheel or whatever.
We owned that bad fact, and we even owned it with damages, that the parents had been somewhat estranged from Hunter. Paula, as Caleb said, was an author, and she wrote a book, The House Built on Stilts, because they had a tree house in their backyard. And when they had to practice tough love with Hunter, they wouldn't let him stay at the house. One night, Paula saw some movement in the backyard, and she realized Hunter had gotten to that tree house to sleep. So she would leave him meals out in that tree house. And she wrote a book, The House Built on Stilts. I'll never forget the day she testified. We walked in the courtroom, and the defense lawyer had her book on his counsel table. And I said, "Get ready, Paula. He's going to ask you about some things in the book." And he said, "Isn't it true, ma'am, that you lost your son long before he died?" and he got a quote in her book, said, "I have lost my child to drugs." And it was so powerful. She was so offended. And she looked at him and said, "Sir, drugs didn't kill my son. Your company did."
Ooh.
It was beyond powerful. And the same lawyer in closing was setting a floor for damages and told the jury they should award the mother more than the dad because the mother was crying and obviously more distraught and loved her child more. So there were some things that were to our benefit coming from the other side.
Sounds like defense was your best teammate.
He's a really good lawyer and a nice guy, but you got to know your jury, and there were dads on the jury. And I'm a dad now, and I just couldn't imagine somebody asking a jury to award less for me because somehow my love is not, as strong as a mother's.
Right.
The first lesson we learned is when you have bad facts in a case that you know are going to come out, and we knew these would come out because it's clearly relevant to a situation where a bus is running over someone and somebody's chasing after a bus. The argument the defense wanted to make was nobody in their right mind would ever run after a bus because they know how dangerous it is. And of course, every witness we talked to said, I would have run after the bus if my stuff was on there. But we knew that was going to come into evidence. And so if you know there are bad facts that are going to come into evidence, your instincts say run away from those things. But what we've learned from trying these cases, a lot of times there's no perfect case, is that you have to get ahead of it. You have to own them. And so Charla, when she went up and did the voir dire, I think she made a statement. You will find out that somebody in this case had drugs in their system. Is there anybody here, who would say, I can't look at the evidence because of that factor? There's a question like that. And so the first thing that she says is letting these jurors know that, hey, somebody had drugs in their system and we're going to own it. And then in opening statement, we just came out and said that.
So it's in owning your bad facts, the way that you did it was introduce it in voir dire, introduce it in opening, be comfortable with witnesses and talking about it. Don't hide it, own it, and let them say, so what?
Yeah, and there was two other things. Our framing in that case was do your job.
And when you say framing, I know you talked a little bit about Mark Mandel, but what is framing?
Framing case is well, you have to read the book to really understand. He goes, what are the issues? And you usually look at a case, and there's 3 to 5, I just can't get over it facts. And there, I can't get over it that are good for you, and I can't get over it that are bad for you. And you need to frame your case around those facts, because sometimes people get so caught up in the details of the case that it's so fragmented you can't really center in on the facts. And if you look at the good facts for us in that case is Greyhound's written policies and procedures said that driver always must take a head count. If there is a passenger missing, they have to take reasonable steps to find that passenger before they leave the truck stop. And so what we said is Greyhound framed his job duties. All he had to do was do his job. Had he done his job, Hunter or anybody else would not have been in the situation where they needed to run after the bus. So that's what I mean when framing it. They needed to do their job. What was amazing is Greyhound never, ever said, yes, it was our fault.
Wow.
Which I wanted to hug them because it was great for us. Because it would have been much better if they said, look, our driver didn't do what he should have done. They said, no, he did what he thought was right at the time, and Hunter should not have run after the bus, and he wouldn't have if he hadn't had heroin in his system. And by the way, we did find a witness who had been a former in management at Greyhound and had been on a bus with that same driver and had her sister on the bus with her, and he had done the same thing to her sister. This was like a year before, and she had sent a memo. We didn't know this when we took the case to Greyhound saying, this man is going to kill somebody if you allow him to continue to drive the trucks. But we didn't find that out until much later in the case, but obviously that had a big impact on the jury.
I'm kind of hearing a lot from that, right? I'm hearing sometimes you just can't make stuff up, right? Like sometimes it's just going to happen. Like, for example, I remember seeing the video deposition of that driver, the Greyhound driver. Man, you talk about the least likable person you could ever imagine, and that's him. So you had these facts that just happened to support it. But then what I'm also hearing is you got to make a list of your 3 best I can't get over it, your 3 like worst I can't get over it, for example. And I think in Hunter's case, one of the worst is he had heroin in his system,
and a syringe in his pocket.
Or he was addicted to drugs, right? And when you do that, then you can come up with strategies to overcome the bad ones and to emphasize the good ones.
Exactly.
Okay.
I encourage anybody, if you haven't gotten, I'd get the advanced case framing book from Mark Mendel.
Yeah.
You can get it on the AAJ website. It is fabulous.
Right. And so some case framings that we've talked about, obviously for Greyhound, the frame was do your job, right? Some other ones that we've talked about in prior cases are inevitability, right? It was just inevitable that this was going to happen. It was just a matter of time.
No free pass.
No free pass. Especially in today's day and age, we've talked a lot about how conservative jurors, in particular Trump supporters, they really don't like it when people get a free pass.
Right. Personal accountability.
Personal accountability, exactly. I'm trying to think of some other frames we've used that have been really effective in our presentation of the evidence.
One thing I'll add is that, we talked about focus groups in Milburn. We also focus group this case. And if
this case, you mean the Hunter's case?
Correct, the
Okay.
Greyhound case, as we call it here. And focus groups, they give you good information, but the one thing they also give you is an Excel spreadsheet for the 300 or 400 jurors. After they've asked them a series of questions, they ask them, what was the most important issue for you?
This is the big data, right?
Correct.
Okay.
What was the most important issue for you? What do you think defense should have hit harder? All those questions give you great information for your frames. You will see the same quotes or the same issues over and over again. And so we had this case, you referred to it earlier last year that we got almost a $72 million verdict in. And it was an unusual case because it dealt with a couple businesses, and we had to go after a parent company, and it was more complicated than your normal case. One thing we took from the focus group was people kept saying over and over again the same thing. They were saying basically the parent company always knows what's going on. They should always be responsible. And that was one thing we didn't think, jurors would naturally, believe or maybe, assume exactly. And they did. And so what we did is we took the natural assumptions from the focus group and turned those things into our frames. And I think in the Greyhound case, the focus group told us what the most important issues were for, the strength of our case and also for the weaknesses. And the other thing the focus group showed us in this case was that the jury would place a little bit of contributory negligence on Hunter Brown. Not a lot, but a little bit. They also told us that, the drugs in his system were not as big of a deal as what we originally thought. And so if you can take the focus group and the big data studies and pair that with what Mark Mendel teaches on case framing, you will have an incredible set of information and very strong frames moving towards your trial.
Let me ask this, since you mentioned it, on a contributory negligence, we've had that in a lot of our cases, right, where the jury's going to maybe attribute some blame to our plaintiff. We've heard a lot of differing opinions on this, but I think ultimately our firm has come to the conclusion, correct me if I'm wrong, that we need to suggest a number to the jury. Always suggest a number. Can you tell us a little bit about that, Charla?
Yeah, I can't remember what I suggested in Hunter's case, but I know I think 5 to 8%. I think the jury might have put 10% on him. I can't remember. But we should say he should not have run after the bus. Now, I think it was most people would, but should he have? No, he shouldn't have. And for us to accept that responsibility, I think, goes a long way.
It's a way of owning your bad fact.
Owning your bad
and
facts
getting credibility.
And not skirting around it. And when Caleb was talking about the Lopez case that we tried 6 months or so ago, when we did the raw data, the big data study, literally probably 20 of those members of the study said this sounds like a shell game.
So we can circle back then to talking about how to own your contrib.
Yeah,
maybe.
Absolutely. And so it sounds like you can always tell a jury, we'll take a little responsibility, but what a little means to people, it really ranges.
We don't say little. We will take our fair share of responsibility.
Share. And then you suggest a number.
Exactly.
Why do you suggest a number?
You always want to have it in the jury's mind. I always say I don't want the jury to go back in the box in the jury deliberations room and ask what Jesus would do. I want them to ask what Charla would do. And truly, I'm not trying to obviously put myself on the level of Jesus Christ, but I want them to be thinking, now, what would she have thought? Mm-hmm. And I don't want them to ever wonder. And so I intentionally went, our big data study showed that 10% was going to be on Hunter. And so I brought in a number lower. So if they wanted to do a little bit more, they wouldn't do a whole lot more.
Did you connect that number to anything in particular, or was it just what you believe to be the fair share?
It was what I believed to be the fair share.
Because I have seen some lawyers say, all right, there was 5 minutes in which he could have done X, Y, Z, so put 5 on him. Do you think that's an effective way of doing it, or is it really just a gut feeling of what you think's fair?
For me, it all usually boils down to the gut. Some of those things that other lawyers do quite creatively, it just doesn't feel right to me, and so I usually go with my gut.
That makes sense.
But going back to a scientific answer on the focus group, we've run studies before on other cases, and working with John, and John's done thousands and thousands, so he can predict what juries will do before they do them.
You mean John Campbell?
Yeah, John Campbell. And so one thing he told us on a case we had a couple years ago is he said, I want to run it both ways. I want to run it with one way you accept some of the contributory negligence they're likely to find, and I want to see what they give you as far as liability and damages, and I want to do it one way where you don't, and you say they didn't do anything wrong. And so we ran it both ways, and what we found is when we said, we don't think they did anything wrong, but if you do, that's okay, because we can understand why you would think that. That version of the script came back with a higher liability finding on the defendant and more damages. And so it's about building credibility. It's about being authentic. And like Charla said, if you know they're going to put something on your client anyway, why wouldn't you get ahead of that?
Yeah.
You look reasonable. You look like you're the person who's doing what's right and fair, and the defense doesn't, because the defense is the only person in the room that can't accept any responsibility for what happened.
Got it. Well, those are the 4 jury trials we tried in 2019 to verdict, with each resulting in an 8-figure verdict. This has been really helpful, not just for me. I hope for our audience. This is our premiere episode of More Likely Than Not. Anything you guys want to add?
I would just say to recap the lessons here so they don't get lost in some of the stories of the trials. Remember, every case you need to think about witness order. You need to think about what makes the most sense for that case. Don't be married to an idea because it worked in another case, or because you heard somebody on a podcast say, you have to call this person first no matter what. There's no right or wrong way to do it. I think it's circumstantial. And if you have those focus groups that tell you what's most effective, you can predict some of those things. The next lesson would be always simplify the complicated issues. You're talking to jurors, you're talking to normal people. It is our job to condense the information and to dumb it down in a way that makes sense for everybody.
So don't take 20 depositions and get 6 experts.
And then, like Charla said, sometimes a verdict's more than money. Sometimes an acknowledgement of what happened to your client can be more powerful than any settlement, any verdict, or anything that we could get from a trial. And then the last thing is, you own your bad facts. Get ahead of those things. Every case is going to have some kind of bad facts. There's no perfect case. If you had a perfect case, you're not going to go try that case, because that case would have settled a long time ago. Figure out what your bad facts are and how to best get ahead of those things in voir dire and opening statement. The last thing we'll say too is, thank you for listening. We are going to do more episodes. We're still trying to figure out what makes the most sense. And so what we invite you to do is, if you have questions, you have suggestions, you have people that you think we should interview, go ahead and shoot us an email. Our email is info@morelikelythannot.com. Our goal is to make this as useful and helpful for everybody out there, and so that, we can have somebody like Charlie, who's practiced for 40 years and pretty much tried every kind of personal injury case imaginable, give you great advice that, most people just can't get. And so, thank you again.
I didn't know our podcast had its own email account.
I had to remember it. I'm like, we do, right?
I know. Caleb's looking at me like, it's that, right? It's info.
Yeah, I
love how he's looking at me. I'm like, I don't know.
Well, let me say this. I think you can tell, and we at Aldous Law here, we actually kind of like each other, and we absolutely love what we do. And we work a lot of our cases up from the get-go, but we're brought in on cases a lot. We try cases all across the nation. If you have a case that you're interested in talking to us about, we'd love to hear from you. We've tried everything from trucking, workplace injuries, explosions and burn cases, dram shops, rideshare sexual assaults, birth injury. Like I said, I even tried an offshore tax shelter case, but I don't want to do any of those anymore.
Please no.
I tried an easement case one time. I don't want to do those anymore. But anyway, your personal injury cases, if you need a partner to help you with your case, please call us. We can be contacted at aldouslaw.com. We'd love to hear from you.
You've been listening to More Likely Than Not, where the Aldous Law team turns small margins into massive victories. Love what you heard? Don't miss an episode. Subscribe now, leave a review, or share this with a fellow trial warrior. Remember, we're all just 0.01% away from tipping the scales. Produced and powered by LawPods.